Just give me 1 minute. I'm just going to mute myself.
Okay.
Thank you for the indulgence. Okay, this worked last night, but tonight it doesn't appear to seem to be working for me.
Ma'am?
Yes, I know. I had two computers on. Last night it didn't seem to be a problem, but now there's some echoing, so I put off the one. So the problem is going to be, last night I could see on the computer on which I'm not presenting whose hands were up because I was one of the group. But now tonight, for some or other reason, I can't see whose hands are up when I am presenting the slides. I don't know why. That is why I thought I needed a second computer. But as you heard, it's not going to work tonight. So those of you who want to ask a question, I can't see your hands. You just have to say, I have a question and ask your question. Into apps, yeah. So when you do have a question, rather just ask me the question and then I will know there's a question. Okay. Having said that, we are on our second last night, our penultimate evening of this lectures. Tell me, are there any questions so far pertaining to anything that we have covered thus far? Doesn't have to be last night. Anything that you want me to explain? And like I say, don't just put up your hand, ask the question. I also can't see the chats from here. I don't know what's the difference tonight. Last night there was no echoing, but tonight there is. Okay, I take it nobody's. Let me just see.
Hello, Advocate.
Hello, yes.
Yes, can we go back to yesterday? That third-party procedure, it's a bit tricky. Can you just explain it again, please?
Third-party procedure.
Yes, ma'am.
Okay, yes. Anyone else with a problem with third-party procedure? Are the others okay if I do discuss it again? Because I know that this is a revision for you. You have done everything like you told me on the first night. This is revision, but I have to do my job, so I'm going to do it. But
please do it again, ma'am. Thank you.
Please, is there anyone that is against me doing it?
Ma'am. No. Can you please do it again?
Okay, I think I'll just do it again. If you have a serious problem with it, I don't know. Let me just find the slides. Okay, it is rule 13. I don't have to find the slides, but I want to find the slides of that. Right, just ignore everything else. Just look at the two vehicles. Now, I've started explaining third-party procedure by first explaining to you what the Apportionment of Damages Act means, right? That is where both owners has contributed to the damage and the plaintiff has contributed to his own damage damages that he is suffering. And the court, when determining the value of the damages, will determine the value. Now, say, for example, the red car was the plaintiff, the green car, the defendant. So the red car, as the plaintiff, claimed an amount of money and proved in court damages to the value of 1,000 rand, right? But the court, in determining the apportionment of the damages, said that the defendant is only 70% responsible for the damages. Your value of your damages is 1,000 rand. Defendant is only 70% responsible. Therefore, the defendant pays you only 70%. The 30% is for your own account because that is what you caused yourself. That is the Apportionment of Damages Act. That is how damages are apportioned in terms of that act. Now, you would remember that I said that Rule 13 is complementary to that. It does not supersede that, but it is complementary to it, right? And then I said there's another person involved here. If the owner of the vehicle, in this example, third-party procedures can be used in other stuff, in other kinds of actions as well. But in this example, if the owner of the vehicle was not the person with the yellow top on, the owner of the vehicle was something else. Let's call that person A. And let's call the person with the yellow top B. And let's call the person in the green vehicle with the blue hat C. Right. Now, A suffered the damages, so A can claim from the driver B. Right? C. A is the plaintiff. The red car belongs to A is the plaintiff. A does not appear on that picture. B is the driver of A's car. C is the defendant, right? A sues C for the damages to his vehicle. A is not suing B. A and B are sisters, or they are close friends, or boyfriend and girlfriend, or whatever. But A does not join B as a co-defendant and say, one of you must pay me. A only sues C. Right? So C is the defendant, A is the plaintiff. Then C can serve and Rule 13 reads as follows. When a person can be indemnified or can expect a contribution from a claim against him from someone else. I'm talking roughly. Let me just give you the correct words. Just hold on. Let me find the rule again. Where a party in any action claims as against any other person who is not a party to the action, in this rule, it is called the third party, that such party is entitled in respect of any relief claimed against him to a contribution or indemnification from such third party, right? So the party that we're talking about here is defendant C. That party, relief is claimed from C by A. A is the plaintiff, C is the defendant. A claims relief from C. C says, but B can indemnify me or contribute because D was partly responsible for the damages suffered by A. So C serves a third party notice on B. B then becomes a third party. B can then also file a plea and he participates in the action. The only difference is when the court makes an order, the court does not make a monetary order against B, but makes a declaration, a declaratory order against B. So the court will again say, A, you prove damages to your vehicle of 1,000 rand. 70% of that damages was caused by C, the defendant. 30% of the damages was caused by B, the driver of your vehicle. But the court is not going to order the third party to pay A, to pay the plaintiff. The defendant must pay the plaintiff, and the defendant can now armed with this declaratory order, go after B, but in different proceedings where the defendant will be the plaintiff and B will be the defendant, or applicant and respondent where they just want to enforce the declaratory order so that the court can then say that B must pay C, whatever C has paid to A. That is the third party procedure. I don't know if that makes it clearer, sir, the one who asked for me to do it again. Do you have further questions on that, sir? I just want to go to that specific slides.
No, thanks, ma'am. It's clearer now.
Okay. Yeah, this is the no judgment sounding in money may be sought against the third party. All that can be sought is an apportionment of fault in the form of a declaratory order. Okay. Remember, if you want to ask questions, ask it. I cannot see your hands, please. If anybody else have any questions, please ask it now.
Good evening, Advocate.
Yes.
My question is on jurisdiction. Sorry to take you back. In terms of when a contract of sale is concluded over the phone. So you said in terms of jurisdiction, when you sue the defendant, you go where the defendant stays, right?
That's one of the reasons, yeah, of why a court would have jurisdictions, yes.
Yes. So now, if the parties are in different provinces, and the contract was concluded over the phone. Say, for instance, the other party is in Limpopo and the other one is in Cape Town. But then the contract of sale was concluded over the phone, and then there was breach of contract from the defendant's side. And then the plaintiff sues the defendant, thinking that the breach of contract happened in Cape Town. But then the defendant raises the fact that the court in Cape Town does not have jurisdiction.
Why? Because the breach did not happen in Cape Town.
Yes.
Well, let's go back to contract, the law of contract. Remember,
Yes.
you studied and where the offer was made, right?
Yes.
But the contract is entered into at the place where the offer was accepted, isn't it? What do they call that? What principle? It was when the letter was posted and somebody gets the letter and accepts the offer, then at that place. Now it would be the same with the telephone. I can't remember the exact principle they call it. The post, I don't know. It's long ago. But it would be where the offer was accepted, then the contract came into being. So where that person was, he was on the phone, but he was at a place. And was the contract in writing? Was it the oral contract, you say?
Oral contract over the telephone.
Oral contract, and they've agreed on the telephone all the material terms of the contract, who must do what and when.
Precisely.
Okay, and that is not in dispute.
No, it's not. But then
at this stage.
But then when the defendant was sued, the defendant raised the fact that the court did not have jurisdiction. There is a case, let me just look for it. It kind of boggled me up because then I was like, but it was said that you go where the defendant is when you want to sue. That's where the court has jurisdiction. So the case is Telpeda Investigation Bureau, Pty Limited versus Van Sale, SA of 1965.
1965.
Yes. Then it states that the question of where the cause of action arose and which court should have jurisdiction was scrutinized. So I wanted to understand whether the fact that when you sue the defendant in terms of where the court has jurisdiction, you have to go to where the defendant stays. I wanted to know if it's a rule set in stone or it's just one of the principles that you would use.
Okay, the reason of a contract, I've got that up, that slide up if you can see it.
Yes.
Right? Applies where the cause of action is based on contract, affords jurisdiction to those division in the High Court within whose geographical area of jurisdiction the contract was either concluded, that is the place of the acceptance of a valid offer, or to be performed either in whole or part where it was performed, or in the area where it was breached. All of those three courts have jurisdiction.
Okay, all right. All right, thank you, Advocate. Makes sense now.
Do you see that slide?
Yes, I do see the slide.
Yeah, those courts will have jurisdiction. It's not the domicilium. Yeah, the ratione domicili. It's not that.
Okay.
It's ratione rei gestai where the cause of action arose. And
All
those
right.
are the three instances where the contract was concluded, where it was to be performed, or where it was breached.
Okay. All right. Thank you so much.
No problem. And remember, you for those of you who's joining late, I cannot see hands tonight. If you can ask the questions, just let me hear your voice, then I will know that you're asking, because I've got the slides open and for some other reason, both is not open at the same time on my computer. So you can just say, excuse me, I have a question, or I have a question. You don't have to make an apology for it. Oh, we did that, eh? We did the okay, so I presume there's no questions. Let me just peek quickly between the two. No questions, right? Okay. So moving along, we did that, experts, and then I said you could ask further particulars. Right. Now, we are still in the stage where you're doing the practical arrangements. You're preparing for the... Is there a question?
Yes. Sorry, I think there was something wrong with my mic or something, because I kept on speaking alone.
Oh, sorry.
I'm sorry for taking you back to... Yes. Apologies for taking you back to judgment. We said a summary judgment can be utilized in terms of recovering any amounts due from a liquidated claim, right?
Yeah, that is one of the instances, yes.
Maybe if there's an agreement of sale or something. Yes. So I need to find out if the claim was not initially liquidated. Let's say a person is sued. From there on, we have an order. So can a summary judgment be utilized to recover amounts due to an order?
A judgment.
And
a court order.
Yes, or a judgment.
But why
yes,
must
a court order to satisfy.
Why must you sue again?
To satisfy any amounts due to a court order.
Okay, I don't understand. Just say that again. You say there was already litigation.
Okay.
You've obtained an order. Now you want to sue again. Same cause of action,
yes,
same parties.
I'm saying for no, like for a finance agreement on a vehicle, right? That claim is liquidated because there's an agreement of sale signed by both parties.
Yeah.
So that claim is liquidated for the dealership or the bank or whoever, which party. Yes, for the party that is owed. So if the claim was not initially liquidated, whereby it's due to me in a sense that I have been able to certify in front of the judge that I am being owed. Maybe if there's rent money. Yes, I'm here.
Okay, now what does rent money got to do with the vehicle? Is it a
In
different
terms of
claim?
outstanding quantum.
Okay.
No, it's not. It's not a different. It's not a different claim for a court order amount that is due in terms of a court order, because with regards to a court order, a person first had to go to court, right?
Yes.
To obtain that order.
Then you
Whereas with an
then
agreement,
you on
the
that court order.
was
You
already
execute on that court order. I don't
okay.
understand. If you already have obtained a court order, you don't go to court again to obtain another court order. You can execute on the court order. Is it for the payment of money, or is it for the return of the vehicle?
For payment of money, meaning for a claim that was not initially liquidated, whereby a claim was first quantified in court.
Yeah, but then if it was quantified in court and the court has made an order, why do you need to go back now for summary judgment? You already got your order.
The defendant or respondent does not comply
with the court.
How do you then compel
you can bring,
the defendant
you can,
or respondent to compel? Can I compel?
You execute. No, you execute on the judgment. Did you go and execute? Did you go to his house? Did you go and write up? Did you issue a writ of execution and try and satisfy the judgment date? That is what you must do.
Okay. So to satisfy the judgment, I will not utilize a summary judgment. I will have to warrant process.
Judgment. You already have a judgment. You don't go to court the same facts between the same parties. You already have a judgment. So that judgment is valid for 30 years. You don't have to do it.
For how many years?
30.
Oh, apologies, you were breaking there. Okay, for 30 years.
Execution, execution, my dear, execution.
Yes, a warrant of execution. You already have your order. A writ of execution. You go and you have a writ issued by the court and you send the sheriff and they go and execute. First, they look at the movables. If they find enough movables, and if there's no movables, they look at whether the person has immovable property, and you follow the process that you have to follow there to get your satisfaction. But another order won't. You will have then two orders for the same thing, and it has the same value. So if you couldn't get it on the one order, like you say, what makes you think another order will be different? You must go and execute. A writ of execution must be issued.
Okay. All right. Thank you.
Okay. Any other questions? I take it there's none. Right. Now, remember, we are dealing with actions. And when you are dealing with actions, you, what is this? Oh, that. When you are dealing with actions, you have to call witnesses who's going to testify in court. So you're going to put oral evidence before the court, right? They testify under oath, it's oral evidence. Now, to get your witnesses to court, you must subpoena them. Now, in terms of the Uniform Rules, Form 60, it's dealt with by Rule 38, Sub Rule 1. That is a normal subpoena. Then you get another kind of a subpoena. That is a subpoena duces tecum. That is, the witness must come to court and bring a document along. Okay. And it is important, in most civil cases, you agree with the witness that they're going to come. Because if it's going to be your witness, there's a kind of they will come, they're friendly, they've got an interest. But what happens when you come to court on the day when the trial is set down and the witness is not there and you have to say, my lord, we cannot continue because my witness is not present. The court will want to know from you, did you subpoena the witness? And if you did not, you'll be in trouble because the court will say you are wasting the court's time. Your witnesses, you were supposed to secure your witness for the attendance of the trial. And you don't just subpoena your witness a few days before the trial. You must subpoena them timeously because the witness can say, I'm not available to come because I only received the subpoena 2 or 3 days ago or last week, and I already made plans to go somewhere. I'm out of the province or out of the country, and I'm not able to give evidence. You must give the witness sufficient time. So you must subpoena your witnesses timeously. Now with the ducis tecum, that kind of when would you use that kind of a subpoena? Let me use the example again of a divorce, right? Wait, let me first go a step back. Remember that we've got the discovery process where the parties, when they are called upon by the other party to discover, then they must give an affidavit wherein they say what documents that is relevant to the trial that they have or had, right? That is between the parties. The witness to which you will send a subpoena ducis tecum is not a party to the proceedings. So you can't send a discovery notice to somebody who's not a party to the proceedings to produce documents. But if that witness has essential documents in his possession that you want to use to prove your claim, then you issue a subpoena ducis tecum. Now, to make it more clear to you, it will be used, an example of an instance where that will be used. Say, for example, it's a divorce and the parties were married by accrual. And one of the things that has to be decided is by what amount the different estates has accrued. And one of the parties, say, for example, the plaintiff is a shareholder in a company, right? And you want, and the other party wants to know what is the value of the plaintiff's shares, right? And it's not the plaintiff's company. Then they can subpoena ducis tecum, the accountant of that company, to come together with the accounting records. Or, yeah, that is when you would use, that is one instance, that is now a long explanation, but I just want to bring it home, that you can ask another party who's not a party to the proceedings, another person, but who have documents that is relevant, to come to court and to bring that documents to court. Okay, and once you have received a subpoena ducis tecum, you can't just refuse to come and bring the documents. If you want to, it can be set aside a subpoena ducis tecum only by the court. So if you are not happy by being asked as a witness, by being asked to bring certain documents to court, you can go to court and ask the court to set aside that subpoena ducis tecum. But then you have to prove to the court that this evidence is not necessary. And the court, a lot of times the argument is that your right to privacy is not protected because now you must give your private company documents for the court. That's usually not a good excuse. If it's relevant to the proceedings, the court would usually say that you have to bring the document. But I mean, you can have a subpoena ducis tecum set aside by bringing an application to have it set aside, and obviously your opponent will then oppose that, and the court will have to make a decision. Are there any questions on that?
Yes. Good evening, Advocate.
Good evening.
My question is based on the subpoena point that you just raised. I wanted to find out, say for instance, there's court proceedings that are dependent on particular evidence which is contained in a document which is protected, I mean, in terms of Section 205 of the Criminal Procedure Act. Let's say, for instance, yes. Let's say it is a document that is withheld by a government institution, and information that is kept in that document is of such a nature that it's confidential, and its confidentiality is of outstanding value. And now the court proceedings cannot proceed without such evidence being given. So I wanted to find out that if for instance, that witness has to come and present such evidence in a court of law, in a magistrate or before the magistrate or the judge, the handing over of that document to that presiding officer, isn't that going to compromise the confidentiality of, because I'm of the opinion that if such document is given to a magistrate or a judge, sorry?
Yes, that would be a basis to have a court set the subpoena aside, and you would explain why it should not be allowed to be enforced.
So that wouldn't that compromise the proceedings?
But just tell me, excuse me?
Yes, ma'am.
Yes, you
Can you hear me?
Section 205 of the Criminal Procedure Act, isn't that Section 205? Isn't that a witness who's a state witness that gives evidence? In my recollection, I know I didn't do criminal law recently, but isn't a 205 witness that turns state witness, who's also part of the commission of the crime? But
yes, yes,
it's not charged.
Yes, it speaks about that, and it also speaks about allowing the investigators the right to access the information which is not for public domain.
Yeah, but now why would such information be in a civil matter? Because we're doing civil procedure.
Okay, no, I'm asking because of you speaking about a subpoena, which is.
Yeah,
sorry?
but I said the court can set it aside. When you bring an application, if you don't want the, but only the court. You can't say that you don't, and then you must explain, obviously, in your application why this would not be allowed to be heard in open court. But the right to privacy, your own privacy, obviously that the court will say no. In some instances, you will have to really convince the court. That
so even if the continuation of the court proceedings are dependent on that evidence that is contained in that document, which is private, such rule applies.
Well, that will be
the proceedings.
Court. That will be for the court to decide. There's no hard and fast answer that I can give you. It depends, because this is in a vacuum that you're asking it. It depends on the contents and the context and the circumstances, and then only can you say, okay, this is the court uses its discretion, and if it is for the continuation, like you say, the court will have to decide whether it is very essential and in the interest of justice, whether it should continue. But I mean, it depends on a lot of other stuff that we don't have here. So there's no hard and fast rule, but like I say, the court has the discretion to set a subpoena duces tecum aside. So you can bring an application, explain all of that, and the opponent who wants that to be enforced can then come and explain for the continuation, and the court will have to make the call.
Okay, no, thank you. It makes sense now. Thank you so much, Advocate.
Thank you. Sure. Advocate?
Yes, you may proceed, yes.
Cindy here, I've got two questions. The one is about the normal subpoena. Are witnesses in civil matters also catered for in terms of transportation and all of that? That's the first question. The second one is the subpoena duces. How late in the trial stage can you bring this? Maybe you realize in hindsight that you didn't consider the company accountant for whatever reason. How late in the trial can you bring them in?
You must do it timeously, because the people can come up with a lot of excuses as to why they're not giving it. And one of the excuses can be that they weren't afforded sufficient time. And that can be valid. Yeah. What is the first question again?
The first question was about transport, accommodation in civil matters.
Yeah. You're talking about criminal matters where the state calls witnesses. That is the state calling witnesses. Here we are dealing with equal parties, plaintiff and defendant. The state's got.
Yes. So the witnesses.
If you want a witness to come, you sort the witness out. Yeah, you must sort the witness out. There's no rule to say that you must pay. It depends on on you and the witness. If the witness says, I'll come, but I don't have anywhere to live and I can't travel so far, then you must sort the witness out if you want the witness to be at your trial. But no one else is going to do it on your behalf.
Okay, thanks.
So that's what people usually do. They pay for the witnesses. They set them up in hotels or whatever. Transport and accommodation, they sort it, but it's for the parties, not for the government.
Okay, thanks.
Okay. Any other questions? Right. Oh, is there another question?
Yeah, just a quick one. I don't know if I would be diverging so much into criminal procedures. I wanted to find out. So if I call my witnesses, what are the procedures that are there, the measures that are put in place? Say, for instance, I need to call a witness, and I've given them ample time to travel to Joburg to come and appear in Johannesburg court for a divorce matter, but they cannot make it. What are the procedures and the processes that are followed so that the court can maybe have their evidence given in camera?
Well, you can apply to court to have them virtual evidence. First of all, when you have your pre-trial conference with your opponent, you can bring this up. You can and if you can get your opponent to agree, then you can go to court and say this opponent agree, and that that virtual evidence will be given. Usually, if it is expert evidence, the courts is not so worried about that. If it's an expert that wants to give virtual lay witnesses, the court will have to be convinced that this lay witness really cannot be at court and why the witness cannot be at court. You can bring an application if a witness is willing or unable to testify. Then you bring an application to court to give that evidence by commission, or you could say that ask the court to hear that evidence virtually, which is a new thing. But the commission has always been on the books. It's one of the slides. I will discuss it in more detail. Yeah, you say you've given ample time. The witness cannot travel, and now but the witness is still willing to give evidence. Do I understand you correct?
Yes.
It's just that the witness don't want to come to Johannesburg.
Yes.
Yeah.
Something just arose before the day of trial.
Okay, you could ask the court to indulge and to give, provided that the parties agree to that and there's no prejudice, you could arrange for that to be done. I mean, yeah.
Oh. Okay,
is
no,
somebody
so
going
much.
to be with a witness when they give evidence? That is all the things that all the training, not the training, the loopholes and the problems and the challenges that was faced with having trials online. Is the witness sitting on its own? Are there other people in the room? Who is looking at the room? Is somebody, if the person is on a laptop, is somebody standing at the back of the laptop demonstrating to him what to answer when he's being cross-examined? All of that, the integrity of the evidence. Because usually the attorney is with the witness and the attorney can show the court there's no one else in the room, that the room is secure, the witness is there alone, and all of that. So there's a lot of safeguards, and the court must be satisfied that that evidence is then correct evidence. Because remember, when you're in the court, nobody can give you answers. But in that situation, the possibility is there. And the integrity of the evidence, we don't know. Because the camera on the laptop can't take up everyone in a room. Yeah.
All right. No, thank you so much, Advocate.
Okay. Any more questions?
Good evening, Advocate. Sorry, I don't have a question. I was just wondering, could we perhaps just jot down the questions and save them for the end, because it's kind of dragging now.
The end of what? Of the course?
Towards the end of the session. Because usually the lecturers give time for a Q&A at the end, so that we can just get through the content of the actual lecture, because the questions sometimes start running on each other and then it just drags the whole thing out.
Okay, yeah, let's see how that goes. Some of you, if you yeah, let's move along and see how it goes. I'm not going to make a decision on that, because sometimes it's just appropriate to ask a question at that moment when I'm discussing something, because otherwise I'm going to have to explain the whole thing again and then explain the question. So I'd like to just deal with that. Yes.
Sorry, Counsel. I think she's suggesting a good thing, but at the same time, we need to interact with lessons in order for us to understand. I think just dumping information and then at a later stage, I don't think we need to interact with your lessons. I think
yeah. I've been doing this since 2006, and while I appreciate suggestions of people, I know what I'm doing, and it will. We won't miss out on any of the information because I'm entertaining questions at this stage. It might look like that, but we won't. We will still cover everything. So I have been doing this, and I do from the first night. I've noticed that a lot of people have their own ideas as to how I should conduct this and what I should do and what I should allow and what I should not allow. I take it on the chin. Yes, I allow you to speak, but when I explain something and you ask the question immediately, I can immediately deal with it. If you're going to ask me at the end of the evening, then I'm going to have to, then a lot of people are not going to know what you mean, then I'm going to have to explain that whole thing over again and then deal with the question.
Thank you.
So
Thank you, Councillor.
I know what I'm doing. I just don't want to be rude about it. Yeah. Okay, let's move on. Right. If you are going, we're still dealing with the practical arrangements. Now you've called you've tested, subpoenaed your witnesses. If you want to use photos or diagrams or plans or models, you know, sometimes your witness will draw a plan of maybe how a building would look because something happened in the building and they're going to tell the court how, where and when they were, because remember, you must place the court in a position as if the court was there so that the court can understand what happened. So sometimes you would need to use plans or diagrams or models and photographs. Now, if you are going to use any of that in order for you to get your evidence on record, then you must allow the other party to inspect these and within 10 days of receiving it, admit it. Now, again, when you admit these plans, diagrams, models, and photographs, you are not admitting that what they're going to say on it is going to be correct. You are just admitting that this is a plan of that building. This is a diagram of that, and this is a model of the vehicle. This is a photo of that area. That is the only thing that you are admitting. If you don't want to admit it within the 10 days, you've received it, but you don't want to admit it, then obviously your opponent must prove it. It can be received by the mere production and without further proof, right? So if you do not beforehand give it to your opponent to study and to look at, then you can't use it in court. Because your opponent will get up and say, but we've never seen this. It was never brought to us. So this should not be allowed. This photographs that they are now talking to, we don't know what they're talking about. Because remember, it's unfair towards you. You are supposed to look at that photos or plans or whatever, go through it with your own witnesses and ask them, okay, so is this correct? And what happened here and how should I ask, so that you can prepare for cross-examination. It can't just be dumped on you in court, right? So the court will have to give you leave to use it if your opponent doesn't admit it, but you must give it to him beforehand, okay? Otherwise, the court can make a cost order and they can stand down so that the opponent who didn't see it goes through it with his witnesses, but he can be prejudiced thereby because it hampers his own preparation for the trial. Okay, so I just have an example of what a notice would look like when you're going to send photos or plans or diagrams to your opponent. I think I still have it. Yeah. You act for the plaintiff in an action for the court. You are in possession of 5 photographs which you wish to tender in evidence at the trial. Draft the necessary notice. The answer, you'll have the heading. Then you just say notice in terms of Rule 3610A. And that is what it is. Where there's a 1 in brackets, that is just the mark allocation, an idea of the mark allocation, right? So please take notice that the plaintiff intends to tender evidence at the trial of this 5 photographs depicting the damages to this motor vehicle, or it can be bodily injury suffered or the scene of the collision, and hereby offers inspection thereafter the defendant, who is required to admit the same within 10 days after receipt of this notice. That's all. That is what the Rule 3610 say. So that is how you would do that notice. And as long as you have given it to him before the time and he had 10 days in which to admit it, even if you don't admit it, you can still use it at court by calling the photographer, when did you take these photos and where was this and all of that, and then it is proved. That is now if it's not admitted. And again, I say admit what the document is, what it purports to be, not admitting the document is correct. The contents of it is correct. Okay.
Advocate.
That must still, yes.
I have a question. When in the slide prior to it, you said 60 days after. Does that mean 60 days has to have lapsed before you are then entitled to give notice for it, or you must do it within 60 days after the close of proceedings?
60 days after close of pleadings. Remember, close of
Advocate, I can't hear you.
I think we lost her. I also can't hear anything.
Okay.
hello.
Hi, Advocate.
Can you hear me?
Yes.
Oh, sorry. Yeah, I thought I was going mad. Karabu, your hand is up.
No, Advocate, we didn't get your response because it went dead silent.
What was the question again?
So the question is the notice for to provide diagrams, you can only initiate that after 60 days has lapsed or within the 60 days of the close of pleading?
After the 60 days.
Okay.
After the 60 days. 60 days after the close of pleadings. Remember, pleadings closes. Now you're busy with the practical arrangements, and 60 days after close of pleadings. Yes, Janus or Janus? Janus, can you hear me?
Apologies, Council, my mic was a bit slow to unmute.
Oh.
There was a question asked here. According to the subpoena decus tecum, the document that is requested, should it be discovered before you can call the witness, or is the subpoena itself sufficient to get the document before the court?
Usually they would give it before you call the witness so that you could have gone through it and know what questions you're going to ask on it. So when you send it to the state, they will give it to you, beforehand, but they will come to court also with that, yes. It is usually before the trial. You won't see it on the day of the trial, and now you have to study it and look through it, and now, I mean, that's going to be a waste of time. You need to have looked at it beforehand.
Okay, thank you very much, Council.
Okay. Yes, is there another hand up?
It's Karaba's hand.
Oh, it's the old hand. Okay. Right. We've done that. Okay, this one, judicial case management. In terms of Rule 37A, once the pleadings have closed, you have to put everything in the file, in the court file, in order, collate it, prepare an index, right, so that the file is now and then you can arrange for a judicial case management, right? So a judicial case management, it's not only applicable after the close of pleadings, but at any time after notice of intention to defend, a judge can be appointed to oversee that the case runs smoothly, the preparation of the case runs smoothly, so that when eventually it gets to trial, everything is in order, right? So a judicial case management system at any stage after a notice of intention to defend, it can be held, right? And in judicial case management, the court then oversees the file and check that everything is in order. And this is before the registrar will allocate a trial date. Okay. Now, in various the various divisions, we have various practice directives relating to how you would go about having judicial case management cases. I don't know, they call it JCM, Judicial Case Management Courts. There's a special court allocated for it, and it's usually to see that everything is in order, no one is prejudiced, they have had a pre-trial already, the matter is ripe to be given a court date. And if anything is outstanding or anything is not happening that should be happening, the court can also give directions and direct the parties to comply with that within certain days. And if they don't, then they can be compelled to comply by going to, with an application to compel to that court. That's basically, I don't have much to say about judicial case management unless I have specific questions that you can just read Rule 37A and then look at the practice directives in the division where you are with regards to that. Are there any questions? Let me just check.
Advocate?
Yes.
Yeah, now that we've got this system called Court Online, how is that judicial management managed? Because most of things is happening virtually. Just upload the case and get the case number from the registrar and upload the further particulars. How is that management actually?
Well, you speaking from Gauteng, eh? Am I correct?
Yes. Yes, I'm speaking from Gauteng.
Because other people are not in that in the same boat. In other divisions, they don't have court online. It's only in Gauteng. I don't know if you're aware of that. Other divisions
I am
still
aware of that.
On the old. Does other divisions also have court online?
Nah, it's only they want to try and scoop in Bloemfontein now, and then also go to the Eastern Cape. But they started with Pretoria and Joburg in Gauteng.
No, I'm aware that Gauteng has it. We have it since.
Yeah.
The end of 2019, just before COVID started, it was implemented in Gauteng. So I remember it started with case lines, and they decided, look, we're going to now go for a paperless court where everything is going to be uploaded. The Department of Justice bought the program from the UK, and they decided, okay, we're going to use this. Let's first do a pilot with the Gauteng. And it was implemented. It started in Gauteng, and then just when we got onto it, COVID happened, and then it was good because then they could still do most of their trials and stuff online because they've already implemented this, and people just were doing stuff online, and cases were uploaded. Yeah. And now it didn't develop further into the other, but the idea was it was going to go in the whole of South Africa. But for this point in time, it is only in Gauteng. So your question was, how is it going to work, the judicial case management? They have judicial case management even online in Gauteng. They've always had it. So you appear before the judge. The judge, you must have uploaded everything onto case lines. Court online and case lines, and then they look at the file and they will tell you, look, what is still outstanding, what can we still do, what must still be done, and stuff like that. I don't know if the other people that are here knows about Court Online. A lot of people are in other provinces. They also litigate in Johannesburg. So and I'm always surprised they actually know a lot more than some of the people in Johannesburg knows about Court Online. Let me just do this if I can. Sorry. Okay, can you see the screen?
Yes, I can.
It's a new screen,
Yes.
It's a new screen. I just want to show you, say for example, this is case lines. So what you do when you're going to upload it, you're going to deal first with court online, where you're going to communicate with the registrars and all that, and eventually the case is loaded up onto case lines, where everything is then uploaded. It is an app. Anybody can download the app on their phones even, or on their laptops. And yeah, when you
what is this uploaded? Sorry to interrupt.
Hey?
You said everything can be uploaded, so I just want to find out exactly what is this which can be uploaded.
Your case. It has to be uploaded in Gauteng. You won't get the case number if your matter is not uploaded in Gauteng.
Okay, you mean the files?
And then people. Excuse me?
You mean the files which relate to the case which you're handling?
Yes, I'll show you now. And people, what did I want to say now? Okay, so I'm going to look at this specific case. I'm going to show you. Here's the case that's uploaded. You will start with a note. To say it's a summons, you will start with the summons and the particulars of claim, right? Then you will have, you will have the summons and the particulars of claims. There's amendment of pleadings. This is what case. So here's a summons, right? This is what it looks like. It is uploaded here, right? Now everybody who's dealing with this case, the attorney for the plaintiff, he opens the file. He must then invite the registrar of the High Court and all of that, so that they can communicate and have the case numbers and that. Then the attorney of the defendant is also invited. If they appoint advocates, then they are also invited. Now, whoever is invited to a specific case, you receive an invitation on the app. There's under people, there's an invite people. So certain people can invite people. Now, all of that people who are invited, whenever somebody uploads a document. So if I'm counsel and I do heads of argument and I upload it, then everybody who is invited gets a notification on their phone that something has been uploaded, even if it's in the middle of the night, something has been uploaded, then they can go check on the app on that specific case, and then they will see, oh, here's the document. That is how it works. So when you are in court, so that is a summons, here's the particulars of claim. When you are in court and you are now talking to the matter, because it's supposed to be for a paperless society, you can then say, if you are now presenting your case, you can click on present, and then you can present your case, right? You will say, can I refer the court to, you can say, can I refer the court to page B3? And then you don't refer the court, but you will, where is this now? You will then say, oh yes, chances, follow the presenter. And when I am there, then they will also be there. Or I can just lead them to the page, or have them view the page that I am viewing. Okay, so direct others to page there, direct others to page, or page directions. So if I'm at the specific page, then I just put direct others to page and window like this, and they must click OK, then the page will open by them, and I will say, my lord can see there, or the witness also with the laptop, and that is how case lines works. So they don't have this in all the provinces yet. That's what I wanted to say. And for those of you, I said I wanted to show you an example of a return of service. When we talked about it, I might as well use this opportunity. This is a copy of a return of service in this matter. So as you can see, this is what it looks like. This is the document that the sheriff completes. So there you go. He served it on that party. He says how he done it. He served the summons on, and he just have a name, Natasha, ostensibly a responsible person and not less than 16 years of age. That is how we say, and that is filed in the court file. Here you can see how expensive, it's probably not expensive for use, but how expensive return of services are. And that is that. Okay. Just to show you a plea.
But
yes, you may ask.
I just want to find out, you earlier you spoke about case lines and then court online. Now, have they integrated now, or is it still separate? Because previously we used case lines, but I know some of our colleagues started to use court online quite a lot, and they're not using case lines anymore. But you mentioned that as if it was integrated.
Well, as far as I know, it is. I don't have court online because I'm not an attorney, and I don't do the work that you have to do on court online by registering the matters in that. That is what the attorneys does. But the case eventually gets onto case lines, which we use in court. So far, we still use case lines in court.
Yeah, we still use case lines from the outset, asking for trial date and so forth. We haven't used court online, but I know other firms are using court online. But it was quite interesting now when you mentioned both.
Well, Ivy, I hear from people, they talk about court online to me, but I'm not required to use court online at all. Court on, because when I upload stuff, it would be on here.
On case lines, okay.
Yeah. But I understand that when you open now a file, you have to open it on court online in order for you to get the case number and stuff. But that is an attorney's work. That would be your work.
Okay.
So
thank you very much. Thank you.
Okay. So yeah. For those of you who are not in Gauteng, just know you can actually download the apps and court online also. And then there's a lot of reading out there as to how to use it and all of that. Right. Is somebody speaking or is it just a sound? Okay. Right. I talked about evidence on commission when somebody asked if a witness doesn't want to come. Now, in the past, they used to use evidence on commission when a witness was unable or unwilling to come to court, and then the court can't go to that witness. So a commissioner would be appointed, hearing the evidence, recording the evidence. The evidence is then certified as correct and then handed up and becomes part of the evidence of the court. Now we know that when we can do virtual hearings, it's now not something strange. Even though the judge don't go then out to the witness, the judge can also participate, and the commissioner don't have to be appointed. But this is still on the book, so just know that evidence on commission can be taken in the South Africa or beyond the borders. Taken this way because it's convenient and necessary for the purpose of justice. And you bring an application to lead evidence on commission, right? It happened a lot of years ago, probably more than 10 years ago, when I was still at the Cape Bar. And I remember some of my colleagues had to go to Scotland or Ireland because somebody that was in an accident while they were on holiday in Cape Town sued the Road Accident Fund, and that person was a quadriplegic and couldn't travel to Cape Town to come and give evidence in court. And I know commissioner was appointed, but the lawyers had to go there to do the examination in chief and the cross-examination. And you bring an application first, and then that evidence was then handed up in court. I suppose now it would be easy then, it can be done before the actual judge and not the commissioner, because it can be done virtually, I suppose. But I mean, this is on the book still. The court may exercise its discretion not only on formal issues, but also on contentious issues. And the court must be satisfied that the evidence is material, and further that the person is unwilling or unable to attend or give evidence in court. Right. Okay. And then evidence on affidavit. A lot of times during you will see when we do pre-trial conferences, one of the aspects that you need to discuss during the pre-trial conference is whether you will allow evidence on affidavit. But you have to, the court also has to be satisfied that the evidence on affidavit is allowed. When you're going to allow evidence to be given on affidavit, obviously then That evidence won't be subject to cross-examination. And usually evidence of a formal nature is allowed to be also on other stuff, if the parties agree and if there's going to be no cross-examination, the court may agree to that. Okay, moving on. Are there any questions on that? Can I just see? No. Right, let's go to the pre-trial conference. Now, Rule 37 is the pre-trial conference rule, the rule that deals with pre-trial conferences, right? In terms of Rule 37, the parties must hold a pre-trial conference and file a pre-trial minute at least for the trial date. Now, the minute is important because if you do not file your pre-trial minute more than 5 weeks before the trial date, 5 weeks is the cutoff, then you may lose your place on the court roll. And this is important because remember, in the High Court, you wait long for a court date. They try to do it 18 months, I said. Sometimes you get surprised and the matter is within a year in court, but mostly it is 2 years and more that people wait for court dates. So if you lose your place on the roll and then you have to apply for another court date, you're just wasting time because then you have to go back at the back of the queue. Okay, so the pre-trial conference minute, the pre-trial minute must be filed 5 weeks before the trial date. Every party, each party must be represented at the pre-trial conference. And you have to discuss certain things at the pre-trial conference. And those aspects that you need to discuss, the agenda for the pre-trial conference, you will find in Rule 37, sub-rule 6, A to L. Those are the things that needs to be discussed during the pre-trial conference. Now, you will, and then the minutes must be completed, and usually the plaintiff would usually call the pre-trial conference, but the defendant can also call the pre-trial conference if the plaintiff don't, so that the minute is filed, right? The plaintiff they would then agree on the contents of the minute, on what they have agreed on, or even if they disagree, but they will state it in the pre-trial minute what they disagree on. It must be signed on behalf of both parties, on behalf of the plaintiff and on behalf of the defendant. And then it must be filed at court. Okay. So if you have regard to Rule 37, you will see that the pre-trial minute, these are the aspects that they must discuss. And I didn't open my rule and I don't want to waste time by going in and out again, but let me just, right. The date, place, and duration of the conference and the names of the persons present. If a party feels that such party is prejudiced because another party has not complied with the rules of court, the nature of such non-compliance and the prejudice, you state that. And then that every party claiming the relief has requested such other parties to make a settlement proposal and that such opponent has reacted thereto. Whether any issue has been referred by the parties for mediation, arbitration, or decision by a third party, whether the case should be transferred to another court, if there's issues that has to be decided separately, or if there are any more at the parties which to make at the dispute, any dispute regarding the duty to begin and the onus of proof, which party will be responsible for the copying and other preparation of the documents, any agreement regarding the procedure of proof by way of an affidavit. So I will still look at a lot of these aspects later on, but these are the things that you're going to have to discuss and give thought to during the pre-trial conference. You mustn't just pay lip service to it and just say yes, 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 no. You must really endeavor to deal with each and every issue. Right. So like I said, I'm going to deal with some of the aspects that I've mentioned now, like separation of the issues, like who is responsible for the preparation of the court bundles, of the files. What else? Settlement, I'm going to discuss still. Yeah, I'll see what more is up there. Right. The purpose of the pre-trial conference is that you must try and reach agreement on certain issues. It's usually of a more formal nature. Those issues, it's usually of a more formal nature, which will eliminate the need to call certain witnesses and have the effect of shortening the duration of the trial and thereby to conserve costs. Also, you agree on other formal procedural issues like the onus of proof and the duty to begin. Now, I just want to say something here. The onus of proof, the party who has the onus of proof usually has the duty to begin, right? Now, you would think it is the plaintiff in each and every case, but it is not the plaintiff in each and every case that has the onus of proof. And therefore, the plaintiff does not begin in each and every case in the civil trial. It depends on where the onus of proof lies. For example, in a case of unlawful arrest, if in the pleadings, the facts is, yes, the person was arrested, then the onus of proof falls on the defendant to prove that the arrest was lawful. Then he will start and lead his evidence, and only then the plaintiff will come and lead his evidence as to prove that it was unlawful. So that is one of the instances where the defendant goes first. The same in labor law matters, where there was an unfair dismissal. If there is an agreement that there was a dismissal, then the onus of proof is on the employer to prove that the dismissal was fair. So the employer will go first and then the employee comes later. Yeah, so that is sorted out during the pre-trial conference. Also, the preparation of the bundles of documents, the separation of issues, etc. This will enable the trial to run smoothly, to avoid arguments in limine, and to allow the parties to concentrate on the merits of their dispute. Okay. Are there any questions on pre-trial conferences? In the past, it was held at the office of one of the attorneys. Now, it is held, mostly it's held virtually because it's about half an hour. It goes quick. The agenda is sent beforehand. The plaintiff will fill in what he says and the defendant, and then they will discuss it quickly and make changes and corrections. And then, yeah, and agree to what must be contained in it. The plaintiff then will fix it. Send a copy to the defendant who will sign it, and then it will be sent back to the plaintiff who will file it at court. Yes, Richard.
Thanks, Counsel. Yeah, thank you, Counsel. I just want to check with you one thing, and it's a very controversial issue. During the pre-trial, is your client allowed to sit in or not? And is it advisable to have your client there or not? I just want to know, when it comes to your client, should your client be there or not? Thanks.
I hear what you're saying. It's usually between the representatives, but it says it is between the parties. But there's no prohibition against the client being there. But I think it is your call. Is it that your client wants to be there? Because there's no prohibition to say the client mustn't be there, but it usually is stuff that the attorneys must sort out. I mean, what does the client know about the onus to begin, the duty to begin, and the onus of proof and separation? What does the client know to discuss those kind of things without? Yeah, but why would the client want to be there?
Yeah, thanks for that. So should you brief when you brief your client and you chat with your client, is to say to explain to him the pros and the cons of him being there? I'm just want to get clarity on that. Yeah. What's the best advice that you long in the game, is to advise us what we should do if regarding the client at pre-trials. Thanks, ma'am.
Okay. Look, if you're comfortable with your client there, by all means, and if the opponent is comfortable with the client being there, by all means, have the client there. If you are if you want a client on certain aspects that you didn't have beforehand, you have the agenda beforehand. If there's anything that you think you need your client's input, you would discuss that with your client separately. First of all, what you and your client discuss is privileged information. And a pre-trial conference is not a round table, like a mediation, a round table kind of thing, where parties are going to, where you're going to take instructions there from your client. Like the agenda you have before, and you know what must go in the pre-trial minute. I mean, the rule has it. So you could go through all of that and take instructions on it beforehand, and then just the lawyers be at the pre-trial conference. But like I say, there's no prohibition. If you're comfortable, and why party is the client wanting to see if you do your job properly, you can even give the client afterwards a copy of the pre-trial minute. Say this is the signed copy of the pre-trial minute, if that is what the client wants to see. But will the client participate in the discussions? Because that is also an aspect. What will they say? Because it's more technical issues that lawyers, must the case be transferred to another court? Who is prejudiced by the non-compliance with the rules? Which party is prejudiced? That is all lawyer things. So yeah, it's not a round table discussion. That can also be arranged if the parties wants to mediate on the matter. But I don't think that is what you're talking about here. You're just saying, and will the client know? Yes, the client will know. You will, you will tell the party we're going to a pre-trial tomorrow. Yeah, I would suggest give say this is what we're going to discuss. Do you have anything specifically that you want to put in? You can go through it with your client, and then you can afterwards give them a copy of it. Because first of all, you're not going to take instructions in the conference from your client because it's privileged and everybody's present. So you will have to go outside and ask your client must advise you, and you must advise him. And yeah, I think it's too much of a muchness.
Okay, thanks, Council.
Answering you. I don't know if I'm answering you, sir.
No, you did. Yeah, thanks. Appreciate.
Okay, sure. Any more questions? No.
Advocate?
Yes.
Yeah, I just want to ask a question. I'd rather create a mock scenario. Say, for instance, two parties enter into a divorce. You find that the plaintiff doesn't have legal representative. They go and institute divorce in a magistrate's court, and then they get summons drafted, and then they are served on the defendant, and then the defendant goes in and hires legal representatives. And along the proceedings, as time goes, the divorce, before it reaches its conclusion, they then realize that maybe there isn't so much assets in this estate, so let us rather settle outside of court. And then maybe there's questions such as pension fund or something like that, which are contested. Is it advisable that when such issues such as like the divorce, the provident fund they're not able to reach settlement by virtue of sitting down and discussing those things and reaching a settlement, is it advisable for them to therefore go and request a date for a pre-trial? And if the answer is yes, how does it work when the other party doesn't have legal representatives and you find that the other party has legal representatives?
Okay, so I must confess, I don't know if it is a requirement. I don't think, I don't know yet if it's a requirement in the magistrates court to have a pre-trial conference. I know they do have pre-trial conferences before magistrates, but I don't, that is something, it's almost like the judicial case management kind of a type of setup. But those of you who are in practice, maybe you can advise us. You do magistrates court work, or do you have pre-trial conferences in magistrates court? Because the type of thing with divorces, you have round table with the parties, a round table where you try and mediate the settlement. And I think that is what you are talking about here. You're talking about coming to agreement on certain aspects. That would not be the pre-trial conference where you have to file a pre-trial minute to court so that the court knows you've gone through each and every, because settlement is only one of the aspects that must be, and you don't even put the terms of the settlement. We must just indicate to the court that we were looking at settlement and the matter is not settled, or the parties still has not decided, whatever the outcome, but you don't give the details of the settlement in the pre-trial minute. What you are now talking about is settlement, and settlement where one of the parties are not legally represented and the other one is. If a party is not legally represented, then that party represents themselves. And if you do a pre-trial in the magistrate's court, I think it's before the magistrate. Those of you who are practicing in the magistrate's court, can you shed some more light?
Indeed, Counsel. It's Jonas here. So I'm currently practicing the match court here at Brits, and it is a requirement for you to have a pre-trial before any case, application or action, to have a pre-trial. However, they do give us some leniency to say it can be either electronically between parties, but they have given us an option to say, if you are struggling with an opponent to have a pre-trial, you need to bring an application for a pre-trial date, set the matter down for pre-trial, and then you can have it in front of a magistrate as well.
Okay. Yeah. So they still have the one before the magistrate, but they've also now have a one that can be just between the parties. Do you then file a minute of what happened in the pre-trial conference?
Yes, indeed we do, Counsel. So it's the standard procedure where you have your pre-trial minute, but apparently our magistrates have also requested us to file an agenda along with it. So it's kind of like your 22A notice in the match court, along with your minute and your agenda therewith. And then afterwards you file it at court. Okay,
so you still have to file it, and it doesn't have to be before a magistrate, but only in the event that maybe somebody's unrepresented or there's some difficulty, it's better to have it before a magistrate.
Indeed, it is, Counsel.
Okay. Does that answer your question?
No. Yeah. Thank you so much. That answered my question clearly. Thank you so much.
Okay.
Thank you, Judge.
Pleasure, Counsel.
Okay. Thank you. Right. Then we come to the final preparation. Because it's we're dealing with high court practice, sometimes you would engage counsel at this stage to do an advice on the evidence. Now, advice on the evidence is where you send all the pleadings and all the documents that has been discovered and everything to an advocate, and you say, please give me advice on the evidence. Now, advice on the evidence, they will look at the law and apply the law to that specific facts and give you an opinion as to what they think the court will decide. And once you have that, then you can now decide, look, must we still run this trial, or must we settle, or what are your chances? But this is only if your client can afford it. Okay, because it's costs. So attorneys can also do an advice on evidence and look at it and do this case strategy where they strategize. This is the facts, this is the law, this is how it's going to apply, and advise the client accordingly. Okay. Consultation with witnesses. This is just brief notes on consultations. I'm sure you all know how to. But with your witnesses, your consultations must be thorough. It is improper to tell witnesses what to say, and you mustn't groom the evidence to sound good and not be a party to distorting evidence. So basically, you must prepare your witnesses, but you mustn't tell them what to say and make up stories to make the evidence good. That will be unethical. It is permissible for legal practitioners to take statements from proposed witnesses, but as a rule, no affidavit should be taken. Don't take an affidavit from your own witness. I know the state takes affidavits from their witnesses, but don't, because it becomes evidence. If it's under oath, it becomes evidence. And should the witness, if you haven't, isn't that, evidence that later on can come back to bite you if the evidence they give is wrong and you somehow your opponent have that affidavit and they contradict themselves and all of that. So it's best just to take statements. You can also consult with your opponent's witnesses. You must just give notice to your opponent that you want to consult, and if you read that, you will see when the opponent can be there or not. The opponents denying you the right to consult, it doesn't help him in any way, because you can consult. The objection is no impediment. Okay, so this is in civil matters. You can consult with your opponent's lay witnesses. You can ask, who's your lay witnesses, and may I consult with him? Just so that you can hear what the lay witness is going to say, so that you can take it to you and say, look, this is what he's coming to say. And you know, okay, this is how I need to prepare. Or tell a witness, this is the evidence is going to be this. How do we deal with that? Right. Are there any questions on that? Because I see it's almost 7. On the consultations with the witnesses and that. That is straightforward. Okay. Let's take the break and come back, and then I'll start with separation of the issues. I'll see you at 15:15.
We're on a break till 7:15.
Right, we are back. I'm now going to start with separation of the issues. Now, this is dealt with in terms of Rule 33 of the Uniform Rules. Right? What the rule says is that if a question of law or fact may conveniently be adjudicated before evidence is led, the issues can be separated. Now remember, this is one of the agenda items that must be discussed during the pre-trial conference between the parties, right? And Rule 33 deals with the stated case and or special case as a patient upon points of law. So when would you decide this? Like I say, it can be decided and agreed on during the pre-trial conference that separations are going to be issued in a claim for damages as a result of the negligence of one of the parties, of the defendant. There is clearly two issues that can be separated, which would first be the issue of the liability, the negligence. Was the defendant negligent? And only if the court finds that the defendant was in fact negligent, then do the court decide on what is the amount of damages suffered, what was the consequences of the negligence, and what damages needs to be paid in order to satisfy the claim. So in that case, those two issues can be separated because you would need different witnesses to prove the liability aspect than you would need to prove the quantum of the damages aspect, the amount of damages aspect. In that case, the court can is the defendant liable, because if the court finds that the defendant is not liable, then you don't have to prove the rest, the amount of damages in that. So before costs for that is incurred and before you run the trial on that, first deal with the one aspect and then deal with the other aspect if it is necessary. Another example of where you would separate the issues is when the defendant has raised a special plea that's going to bring an end to the proceedings. Like, for example, the special plea of prescription. If the parties can agree that the issues and that the court must first deal with a special plea, because if the court finds in favor of the plaintiff that who raised a special plea of prescription that the claim has prescribed, then it's not necessary to go into the merits of the claim. So that is another example of where you would separate the issues. Now the parties can agree, and if the parties don't agree, say the plaintiff say, no, I don't want the issue of the liability and of the quantum of the damages to be separated. They say that in the pre-trial conference, and the defendant say, look, but let's first deal with the one aspect. Then the defendant an application to have the, so if the parties can't agree, an application must be made to the court, and then the court will decide whether it's going to allow the issues to be separated. That's all I have to say on that. Are there any questions on separation of the issues? A stated case, like I also mentioned stated case, it's not on, I don't have a slide on it, but the stated case is when the facts are agreed on, which there's no issues with regard to the facts. There's only issues with regards to the amount of damages. The parties must only argue on the amount of damages. Then the parties can prepare a stated case where they set out all the facts that are agreed to, and it is signed on behalf of the plaintiff and on behalf of the defendant. And then the facts are set out, and you don't have to call the witnesses to prove that facts. And then you would argue an amount of damages if that would be a stated case in terms of Rule 33. The rule calls it a special case. In practice, they talk about a stated case. Okay, so there's no settlement, but the parties agree on the facts. They just don't agree on the other aspects. Okay, any questions? None. Let's move on. Preparation of the court papers. Now, to prepare the court papers, also one of the agenda items in the pre-trial conference. It is a duty of the plaintiff's attorney to arrange, paginate, and bind together all delivered papers and to deliver a complete index thereof at least 5 days before the hearing. Now, I did hear from some students that in other courts, it's not 5 days, but more than 5 days. The rules actually says 5 days, and it is rule, if I'm correct, it's rule 62. I just want to make sure. Yes, 62 that deals with the preparation of the court papers. It's one of the uniform rules, and it says it must be delivered. Does it say 5 days? Let me just see. Doesn't say 5 days.
The notes do say at least 5 days before hearing.
Yeah, that's what the notes say. Now I'm talking about the specific rule. I'm looking at the rule and see if the rule. But I mean, in each court they would have different directives as to when it must be done. But this is very important because if it is not done, then your matter can be struck from the roll. That means that you have to go back in. Apply for a new court out, and there's an important thing. I know in the Gauteng division, in their practice directives, if your matter was struck from the roll for whatever reason, you were not ready, you didn't file a pre-trial minute, you didn't prepare the court papers. If a matter is struck, the plaintiff who wants his matter to be heard, the plaintiff usually wants his day in court and prove his claim so that he can be paid out. If your matter is struck from the roll, then before you can re-enroll it, before you can apply for another court date, you have to also file an affidavit, the attorneys of the plaintiff. And in that affidavit, you have to explain the circumstances under which the court deemed it necessary to strike it from the roll. So you don't want to go through all that trouble and have to explain to the court why the matter was struck from the roll, why you were not ready, and that you need to re-enroll the matter again. Okay, so that is not good for you, for your client. 5 days, it's usually before things changed because courts became overburdened with files and that. But this was usually the procedure. The JP of a division or where there's more than one high court, where there's a local and a provincial division in a specific province, the person in charge, it can be either the DJP or the JP. He will now allocate in that court of which he is in charge. He will allocate matters to the different judges in that division, right? So he knows how many judges available. He knows how many acting judges or acting judges. He knows how many judges is sitting, and he also knows which judge is busy with which case. Right? He's the manager. He knows all of that. So he will, if you do paginate and you file and everything is in order, he will now allocate that specific matter to a specific judge who is available for that amount of days, who doesn't have another matter coming up or must do something else. So he will know. That is why it is essential that you do this timeously so that he can do his work properly and allocate it to a judge. It has a continuous role. So a matter runs from the start to the end continuously without interruption. If it is necessary, if it can't be out, but they hardly do that. In the match court, it's a different case. There, a matter is set down for 1 day, sometimes 2 days, it is heard. And then at the end of that, if the matter has not been completed, they would then, everybody would take out their calendars and would look at when they are all available, and they would say, okay, the plaintiff's attorney is available, defendant and the magistrate. and then they would agree on a next date, and then the matter will continue then. That doesn't happen in the High Court. In the High Court, we have a continuous role, so the matter will start unless there's a recess in between. If it's so, then it will continue again. And it has to have been set down for that amount of time. So it is also there's also in the practice directives of the division a rule in the High Court that you have to find a practice note in which you would estimate the amount of days that you need. So you would know the case, you know how many witnesses you are going to call, you and your opponent in your pre-trial conferences, you would talk about how many witnesses they have, because together you will come to an agreement. Okay, I think we need 5 days or we need 4 days, and so on. And then the practice directives makes provision if a matter is going to be of long duration. It's usually a matter that 5 days. Then you have to make a special application in terms of the practice directives to have a matter of long duration allocated. Now, before that date, before a matter is allocated, the matter must be ready. And if it is not ready to be allocated to a judge, the file is not in order, then your matter will be struck from the roll. Okay, so it's important that you make your matter ready. And what they mean by paginate and bind together, there's also rules with regards to that. In the practice directives, you will find specific rules. They say, I know it's in the Cape Town rules that they say, and it mustn't be, I didn't look at the Joburg rules, because usually the attorneys do that. It mustn't be more than 100. You have different bundles, and there mustn't be more than 100 pages in a bundle. And the file, the court file must be so that if you open the file, the page mustn't jump back. It must remain open. Remember, the judge is now sitting with the file before him, and if he opens it on a specific page and he looks away, it must remain on that page. That kind of things are discussed. So just have regard to the practice directives when you go in a specific division. If you with it, what do they? Okay, because some judges are very pedantic about these things, and if you don't comply, they might strike your matter from the roll. Are there any questions or remarks, or things that you want to add of your division? Okay, we move on. Rule 34, another aspect that you have to deal with during your pre-trial conference is you must indicate whether you have considered the option of settlement, right? So settlement, Rule 34 deals with settlement. Now, you get two kinds. You get the unconditional offer that brings the litigation to an end. It can be a settlement of part of the claim, which will bring that part of the claim to an end, or it can be a settlement for the whole claim, right? In this case, in this kind of settlement, the unconditional settlement, the defendant says, I am liable in respect of the claim and I will pay, or in respect of some of the claim and I will pay. That is the first kind of settlement. Then you get a second kind of settlement. Sharing is paused. Okay, can you see my slides? Sorry, I just got a notice that you can't see it.
Yes, Advocate, we can see your slides.
Okay, okay. Right. Then you get the second kind of settlement, and this is the without prejudice settlement. This is now the settlement where you settle the matter, but you are not admitting liability. You're not saying, I pay because I am liable. No, you're saying this is just for settlement purposes that I want to settle this matter, and not because I say that I do. Yeah? And a lot of times people, many of the cases that are settled on this way without prejudice. So you would look at your case and you would look at the chances that you have in court, and you look at your opponent's case and the chances that they have in court, and then you make a decision whether you want to make an offer to settle. This is now the defendant, obviously, that will make that decision, right? And this is only in the case where money is claimed. Or part of the claim is for money. You can then make an offer to settle. If it is for the performance of some act by the defendant can also at any time tell that he's going to do what is required of him. Okay. Yeah.
Advocate, I've got a question. It's Tolofelo.
Yes, Tolofelo.
So are we able, okay, let me just give you a background of the matter we basically dealing with at work. It's an employee who basically took the department to the labor court regarding compensation. So what had happened was the person was acting in a post of which at the time the post was vacant, and then but there was no acting letter. You know, in government, they will give you an acting letter that you are currently acting in the post. But they were compensated for the work being done. So they would get like performance bonuses and all. Then the labor court ordered the department to pay them the money and then take them back to their post. So now the state attorney is saying we need to, so now the HOD wants to settle out of court now, right? But the state attorney is saying you need to first comply with the court order and then do a settlement. So I want to know, is it possible to settle, still do a settlement offer after the court has done an order to say you need to pay the person the monies and then demote them back to their level?
So the court said you need to pay, the court order said pay the people.
Yes.
And demote them.
Yes. And then you take them back to the post that they qualify, because the person was on a level 7 acting in a level 9 post.
Okay. I got you. Right. In this case, the court has. So why would they want to settle the court order now? Is that it? They want to do they want to pay less than what the court ordered?
Yes, they want to pay less because they basically want to then, because the people have actually now left the department and now it's a matter of paying them off. And now the department wanted to actually pay them on that level they were on, but they actually want money from that level 9. That's how they want to be paid off.
Is it them wanting to be paid, or is it the court that ordered that they must be paid?
It's the court that ordered, because the court said the fact that,
There's no way out there. They are entitled to what the court orders. The matter was adjudicated on, the court made an order, and they are entitled to being paid as to what the court ordered. There's no room for settlement at this stage. Settlement should be before the judgment.
So what must happen now is that the department just needs to comply and not say, let us enter into negotiations.
Of court. There can be a writ of execution because and then the things can be attached so that it can be the judgment can be satisfied what those parties can do, because they were successful and they are entitled to get what the court gave them in terms of the order. They not require, they don't have to settle now. And you don't have to settle at any time. I mean, you always have the option of saying, look, I don't want to accept, it's an offer, I don't want to accept it, let's go to court. You always have that offer, that open to you. And they opted to go to court. The no settlement was before the court proceedings, or before the court handed down judgment, because you can offer a settlement up until before the court gives judgments, and then the party can consider and accept it, and then you can tell the court the matter. But once the order has been granted, and remember the order is valid for 30 years.
Okay, I hear you, advocate. Yeah, because this afternoon we had a consultation with state attorney and there was a back and forth on what must actually happen, because my understanding was that we just have to comply with the court order. We can't be doing settlements after. Okay.
And is the state attorney in agreement with you, or does it agree
State
with
attorney is on some, no, let's take it for review. And I mean, there's counsel brief, Chair. For me, I feel like they're just trying to lose the department.
If they want to take it on review, but a court order, or is it an arbitration order?
I think it's the arbitration order that they want to
And it's
take
not
for
a court
review.
order, it's an arbitration award. You can still take it on a review.
Okay.
The award can be taken on a review if they don't want to, and yeah, or they can because the award is not the order of court, or they can settle. No, then they can settle. Yeah, you said a court order, but an arbitration award is can be reviewed still, taken on a review.
Okay.
Okay.
All right. Thank you.
So the state attorney is correct when they say that. Can be
Okay.
taken on review. Okay. Right. So I just want to tell you something about this without prejudice. Now, you would hear those of you who are in practice, and you would know this better than I, attorneys as attorneys, as candidate attorneys. Without prejudice is when you look at your case and you look at the facts, and then you can decide, look here, to go away. Going and running a trial is going to cost us a lot more, and it's a lot of more effort than that. And to avoid all that, I'm going to just make an offer and see if the defendant accepts, so that the matter can go away. Okay? It's basically paying the matter to go away. You make a reasonable offer to your to the plaintiff. The offer reasonable in the case that the plaintiff must be placed on a risk, so that if they do not accept the offer, they run the risk. And I'll tell you now what risk they run. When you make an offer, you do it in writing. If it's now well before the trial, and they have 15 days in which to consider the offer, and after the 15 days, the offer is off the table. Okay, they can make a counter offer and say, look, I see you offered me 1,000 rand. I would like 1,200 rand. Then I'll go away, and then you can decide. You can look at it and decide whether that is fine. And then you can come to an agreement, and then you have a settlement, and you can then make the settlement an order of court, and then you owe that money. Okay. Say, for example, the plaintiff claims.
Advocate.
Yes, sir.
Just clarity on the explanation you just gave now, the one for without prejudice, where you are saying you will be offering to settle but not admitting liability.
Yes.
Do you maybe please have maybe a practical example where I will be saying I'm not liable, but I'm offering to pay? I understand you are saying to pay off the matter so it can go away. But where I'm saying I'm not admitting liability, but I'm offering. Am I getting it? Did you say it like that?
That is exactly what I said. It stands on the slide also. The party denies liability.
But
most of the matters are settled like that.
Is it? Okay.
Office. That is, look, I make you, but just because I'm offering, I'm not telling you I'm liable, because if you don't accept this offer, it doesn't mean I said I'm liable, I wanted to pay. Now we're going to run the trial, and now we're going back to the basics. I still say I didn't do it. I still say I wasn't negligent. Although I made an offer, because they... Yes?
Sorry, Advocate, I wanted to offer an example, a very practical example. And this happens quite often in the workplace, particularly on the labor matters. For example, you might have an employee that has breached quite a lot of the employment codes, and you've given them a first warning, second warning, and then, you know, the final written warning, and eventually it gets to a point where you have to fire them. You fire them, they decide to take the matter to CCMA. And then before you get to CCMA, you just say, you know what, I don't want this process to drag any longer. We'll just pay you out whatever the amount that you agree with the employee. And then that matter is settled there and there. As an employer, you know very sure that you were not wrong. You were not in the wrong. The employee was in the wrong, but you just do not want to drag the situation any longer because it costs so much. You have to have your HR representatives there. You have to have your legal representatives and the managers. And it just takes so much time, very expensive time from people that should actually be doing work on the ground and be driving your production. But then you decide, you know what, we'll pay whatever will be acceptable to the employee. You do that settlement and then it's done and sorted. No one is accepted liability. The employer is not saying, yes, we were wrong, but they're just saying for this to end, let's pay this guy out, and then the matter usually ends.
Yeah, it is to avoid the whole trial thing, and that you make an offer to settle to make the matter go away. But you're never saying you admit liability, because if they do not accept the offer, they can't say you admitted liability. There is a prohibition to divulge to the court the terms of the settlement agreement of the without prejudice office.
Oh, thank
so
you
you
very
can't
much.
come.
Yeah,
Excuse me?
Thank you very much. It's clear. I understand now.
Okay. Yeah,
Yes.
you can't divulge to the court that, look, you can't during the trial now start and say, my lord, but we offered them 1,000 rand and they didn't want to take it, and they just wasting the court's time by coming here. This matter could have been finished. You can't argue that. You don't tell the court about an offer without prejudice, because nobody has admitted liability. If they had admitted liability, then it's an admission, then the court can know. But if you made an offer and they didn't accept it, then you can't bring it to the attention of the court. But, and there's a big but here. Like I say, you make a reasonable offer and you put the plaintiff at risk. They have 15 days in which to consider. If they reject your offer, if they say no, they claimed 1,000 rand, you offer them 600 rand because you think that's fair and reasonable. They say no. It's 900 rand. I don't want your 600. You say no, then you decide, okay, let's go to court. So remember, they can't now tell the court. The only thing in the pre-trial conference is we considered settlement. That's fine. The court must know you at least looked at the option of settlement, not the terms. Now you they bring all their witnesses and they lead the evidence, and at the end of the day, the court makes an award. Then the court says, okay, plaintiff, you are successful. You've proved here in court damages to the value of 500. Sorry, 500. We're talking about 1,000. 500 rand. So you are successful. You proved 500 rand. Then, at that stage, when the court hands down judgment, and there was an offer on the table that was more than what they have proven in court, you tell the court, my lord, there was an offer of 600 rand, which they rejected. And now, my lord, they have only proved damages in your court of 500 rand. That will impact the fact that they will not get their costs, even though they are successful in proving their claim. They will not be entitled to their cost because they did not accept a reasonable offer. That is why you say you by giving them a reasonable offer, so that the case they didn't accept it, they rejected it, they prove less than what the offer was, they won't get their costs. Like, you know, the rule, the successful litigant is entitled to their cost. They won't be entitled to their cost because they should have accepted that reasonable offer, because they couldn't prove more than the offer that was on the table. Okay. Yeah. This is just the prohibition to disclose tenders without prejudice to the court before judgment. You would only do it if it is necessary in the case where the court orders less than what was on the table. Are there any questions on that, settlements? Right, we move on. Interim payments, Rule 34 capital A deals with interim payments. Now, an interim payment is usually made if the claim by the plaintiff is a claim for damages for damages for personal injuries under the heading loss of income or past hospital expenses. Only for those two heads of damages can you claim an interim payment. Now, when can you claim an interim payment? When the defendant has admitted a liability, when the defendant says, look, I am liable for your damages. So the issue of liability, or they refer to it, the merits of the matter, has already been settled. Or if the court heard, there was a separation of the issues, the court heard the matter, and the plaintiff was successful in proving that the defendant is liable. And now they are waiting for a new court date, which is going to be in 2 years' time, to hear the quantum of the matter. There was a separation of the issues. In that case, you can apply for an interim payment because the defendant already is liable. Either he's admitted or the court has made a judgment to say that he is liable. There's a proviso. You can claim for an interim payment provided that the defendant can pay. He must either be an insurance company or he must have that money. For example, a lot of interim payments for road accident fund claims where there was a separation of the issues, or where the road accident fund conceded the merits. The same for medical negligence claims against the Department of Health. If they have conceded merits, or if they were successful with the liability aspect of the claim, then they can, while they wait for the date for the quantum to be decided, they can claim for an interim payment only in relation to loss of income and past medical expenses, right? The court, you bring an application, so there's a notice of motion, and in the affidavit, you must satisfy the court that the defendant has in writing admitted liability, or that the plaintiff has obtained a judgment on the merits of the damages. Sorry, the merits for damages, that the quantum must still be determined, and the defendant must be covered by insurance or must have the means to enable it to pay. And an interim payment, it depends on what the amount of the claim is. I've seen interim payments of 5 million being paid, where the claim is for 29 million, and they brought they were successful with the liability, or the defendant agreed that they are liable, so they brought an application for interim payment while they're waiting for the matter to come to court again, of 5 million. So in the supporting affidavit to such an application, the following must be set out: the grounds for the application, the amount that is claimed, any documentary proof that is relied upon, and an allegation that the opposite party admitted liability in writing, or that the plaintiff has obtained a judgment against him for damages. Right. Then you will get your...
Sorry, does this apply in your medical negligence matters and RAF, or just when does it?
They usually use it in medical negligence and RAF matters, but you can use it in any matter where the defendant is able to pay and has admitted liability, where it's a claim, but where it's under the heads of damages, where there's loss of income and where there's medical expenses. Because remember that the hospitals wants their money, and now you must wait another 2 years for a date. And maybe it is the breadwinner of the family. There's children, they must eat, they must go to school. There's no income. Part of his claim is loss of income. So you must just demonstrate he can't work now because of these injuries, and he's unemployed. He needs an interim payment so long to cover him until the matter is finally heard. And there's already an admission of liability or an order for liability. But it's used in RAF, but in other cases it can also be used if you can prove to the court that the party can pay, or it can be an insurance company also, yes. But it's only on those two heads of damages, only for loss of income and for medical expenses.
Right, thank you.
Okay. That person who works for the Department of Health can tell you more. Is it you or is it someone else? The one that was speaking earlier on about no, it was the Department of Labor. It wasn't the Department of Health. Sorry.
No, it's economic development, but I've also worked at health, just that I was not in the legal services. I was more on the labor appeals.
Okay.
Hence, I was asking advocate because there's someone who's got a medical negligence matter against health, and she says the attorney is currently giving her stipends of 2,000 rands every month, but she's not even sure whether the matter has gone to court. Her daughter is disabled due to the complications that happened during birth. So now she's very, Pardon?
Cerebral palsy case. This is a cerebral palsy case.
Yeah, it's a cerebral, yes, that one. So
okay, did you see that program on Carte Blanche now recently about that one attorney? Is it that attorney?
No, it's not that attorney. Now, this is a different attorney who's actually doing that. So she wanted to understand that, is he not going to, once the matter is settled, is he not going to take the stipends from that money? Like, why is he giving her money? Hence, I had an interest in this particular, that does it apply to medical negligence as well?
Is in what province are you, ma'am, if I may ask?
In Gauteng.
Okay. Okay. Yeah. You can just get in the court file and see if there was a court order, if there was an interim payment. So you can tell your client you must get, you can get, and anybody have access to the court file if you have the case number. You can look at the court file and see what's happening in the court file. Okay,
right,
so there will be copies of all the orders and if there was money paid and money ordered. So, yeah. Okay, I'm moving on. I don't know if there's hands. Let me just have a peek. No, there's no hands. Right, let's move on. Attorney's duties during the trial. Your notes, read through your notes what your duties are during the trial. This is from the point of where a counsel is appointed to do the matter in the High Court and what the attorney's role is. Assist counsel, do the copies, take instructions from the client, know the case as if you are going to present it. That is your duties during the trial. Okay, so this is from that point of view, but remember, you can also now do your own matters if you have practiced law for 3 continuous years, you apply and then you can do your own matters. But you have specific duties during the trial if you are accompanying counsel who's doing it. And it's just basically running around and doing stuff. Yeah. And not, I'm not even going to go there. I wanted to say something. They talk about wise and being good and not being clever, but being wise. Read your notes. You'll see what I mean. Right, security for costs. Okay, what is security for costs? It is security for costs. Remember, we talked about costs a lot. Costs is what is awarded at the end of the trial. It is also one of the prayers that you pray for. So we're talking about that costs, right? We know what security is. It is, I give you security that there's going to be costs. This is what we're dealing with now. And this is in terms of Rule 47 of the Uniform Rules, right? Now it says, the rule says the party entitled and desiring to demand security for costs from another shall, as soon as is practicable after the commencement of proceedings, deliver a notice. So if you desire that your opponent must give security, you must, as soon as practicable after the commencement of the proceedings, deliver a notice. And in this notice, you will say that you demand security for the costs, right? If the amount is contested, then the registrar can determine what is a reasonable amount. If the security is not given within a reasonable time, the court may dismiss any proceedings instituted or strike out any pleadings filed by the party in default. Right, so what am I saying here? If you are the defendant, the sheriff comes and he brings you a process. Let's say it's an action procedure. He brings you a particulars of summons and a particulars of claim where you are being sued. Now you know you have a defense and you know this is a nonsense case. You know some people sue other people for frivolous things. You now have to go and see an attorney. You have to now incur costs because you want to defend this matter, because if you're not going to do anything, we know about default judgments. So you can't not do anything. But you have the option of serving a notice that the defendant must give security that the cost is covered at the end when you are going to win your defense. You don't have to say you're going to win, but should you win, the cost is secured. That is why when you give this notice, right? In certain cases, you do it, you always do it. In other cases, you do it when it's vexatious proceedings. People are taking you to court for stupid things. You know they don't really have a case. They just want to annoy you, and then they take you to court. Then you can ask for security for costs. But when you do it, as a rule, is when the plaintiff is a peregrine who sues you, that is now not a citizen of South Africa, and he sues you, you can ask that he gives security for the cost, because how is he going to pay the cost if you don't have property here that you can attach? He must give security for the costs. If it is a company or a CC who may become insolvent, you want for them to give security for costs so long before you're going to give your defense, before you're going to give even a notice of intention to defend. If it's an insolvent who's suing you, you can also claim security for costs at that stage. And how is security given? Now, security is not necessarily money. It can be an amount of money that you give as security, a check for that amount, a guaranteed check for that amount, or it can be anything of value that is movable and tangible and that have value. And it must have value when the trial ends. So there's a reported case where a peregrine was the plaintiff and there was a notice served on him and he offered a truckload of mangoes as security, and the court then decided, no, they went to court because the defendant didn't want to accept that, and the court made the decision that that is not security, because by the time the trial will be, that the mangoes will no longer be of that value. So it must be of value at the time when the trial is, right? It can be jewelry, it can be whatever of value you have. Give it as security so long, and you give it to the registrar of the court to keep. You give it in the possession and they will keep it until the matter is done. Now, if the parties can't agree with what is the amount of security, for example, you say the cost of this matter to defend it, and when I win it at the end, will probably be 200,000. The registrar can say, no, that is too much. Let's make it 100,000, or let's make it whatever amount they think is fair, right? And if the parties, and remember, they say you must pay within a reasonable time. Now, then the plaintiff has a reasonable time and not pay, give the security. The plaintiff has a reasonable amount of time to give the security. And if it doesn't give the security, then the defendant can go back to court and have the claim struck or set aside. Let me just see what is the words that is used. I'm thinking I'm talking nonsense here. If the security is not given within a reasonable time, the court may dismiss any proceedings instituted or strike out any pleadings filed by the plaintiff in default, by the party in default, sorry. So that is the words. The claim can be dismissed if security is not given. Now, if you don't have the security to give, you can approach the court and ask the court to then set aside this notice and that you must be allowed to proceed. But in that case, you have to convince the court that your case is not a nonsense case. It's not vexatious proceedings. You have a real prima facie case that the defendant needs to answer, and that your constitutional right to the court or the access to justice is being infringed if you are not allowed to. And the court will never close the doors of the court just because somebody can't pay or don't have security. The court won't close the doors. The court will first decide whether there is a real case. And if there's a real case, the court will say you don't have to pay security, and then you will participate as normal. Cost only becomes an issue at the end of the trial. Okay. In cases of people who are represented by legal aid, Rule 47 capital A says you can't serve them with the security for cost notice. Okay, because I don't know if this is the real reason. This is just my inference that I'm drawing. Legal aid don't take cases that doesn't have merits to court. They will first sift through the evidence and see, okay, this case has merits. We'll take this case on. So it won't be vexatious proceedings and that, because that's not something that they have a system that they will be bothered with. Are there any questions on security for costs? Right, we move then on. Right, so we come to the conduct of the trial. I'm just going to give you brief information. They do have, this is part of this High Court practice course. Obviously, they won't this in the exam. I don't know. No, let me not talk nonsense. I don't know what they're going to test you on, but I know most of the question paper consists of drafting. So this is advocacy training. That's why I'm saying that nonsense. But ignore that. Just now they ask you this, and then you say, I said you won't be asked. Maybe you asked it. Right, the conduct of the trial. Now, we are now finished with the practical arrangements, and we've done a few other things that you have to look at during the trial. Now we come to the conduct of the trial, where we start with the opening address. Now, usually the person, the plaintiff or the defendant, whoever has the duty to begin. Remember, whoever has the onus to prove has a duty to begin. So whoever has the duty to begin will give the court an opening address. What is an opening address? It has the same status as an argument at the end of the case. It provides the court with an overview of what the case is about and identifies the issues. So you would start by telling the court, my lord, this is the case. You will say, this is the case based on a contract. My lord will see in bundle 1 on page whatever, there is a copy of the contract. And my lord, the issues between the parties is that there was a known non-performance or whatever. You will tell the court the story, and then you will say, and to prove the plaintiff's case, if this is now the plaintiff starting, I will call 3 witnesses. The first witnesses will speak to the signing, the second to that, and what. That is how you will deal with that. That is the opening address. It is a guideline to the court so that the court knows what to look out for, and so that the court understands why you're going to use and how you're going to prove your case. Now it's just up to you to prove your case. This is not yet evidence. It is like a roadmap to the court. This is what's going to happen, and this is how it's going to happen, so that the court can follow and knows what you're doing. Right? That is the opening address. Now, again, I've already discussed judgment at the end of the plaintiff's case. I've already discussed absolution from the instance. I've just got it here again, what the test is and that. So at the end of the plaintiff's case,
sorry, advocate.
Oh, is there a question? Yeah?
Yes. I just wanted to check something on the opening address. Obviously, I lay out the plan of what I'm going to show, what I'm going to do, and all of that. But can I almost attack my opponent's case and say that, well, my opponent is going to rely on this, or my opponent is going to try and prove this, but this honorable court should be able to see this and this and this, because I already know what they're going to do based on the discovery and the papers that they've submitted. Is that allowed, or should leave that for when you are actually
that is
now?
Basically for the argument at the end of the case, when the court has heard what your opponent has done. Because, I mean, you don't know, you're going to speculate as to what really, how they're going to do. Look, you more or less know what documents they're going to use. Not more or less you would know, but you telling the court how you're going to conduct your case.
Okay.
But you can say to the court, when you talk about the issues in dispute, you can say to the court, I refer the court to the particulars of claim. This is what we allege. And my lord, if I refer your court to page so-and-so of that bundle of the plea, lordships will see that this is what the defendant's defense is, and they say this is it. You can point out facts that is already before the court to the court.
Okay. So no
But
opening
not
like
argue at the stage. Not argue at the stage. Argue at the end of the matter. Because you're going to get the opportunity to say the defendant is talking nonsense and it's wrong and whatever. You're going to get that at the end of the case.
Yeah, I think we've all watched Boston Legal and we've seen Alan Shaw how he does this thing. So we just need to be careful.
Yeah.
Okay. No, thanks.
Yeah.
Thanks.
What is it? Wasn't it Danny something? Danny, I can't
Danny
remember.
Craig.
Danny Craig, yes. Yeah. Okay. Right, that is that. Then we come to examination in chief. Now, I must admit to you that I still struggle with examination in chief. There's a rule with examination in chief, and this rule is that you are not allowed to ask leading questions, right? And it's not easy not to ask leading questions, right? Now, what is a non-leading question? A non-leading question is, they say, an open-ended question, right? Examination in chief is where your own witness testifies and you establish a prima facie case. That is what examination in chief is. The rule is you are not allowed to ask leading questions. A leading question is a question that suggests an answer. That is what the leading question is, where the witness must just say yes, or the witness must just say no, or the witness says yes, that you ask, you actually, as the legal practitioner, gives the evidence. You say, so on this day, you saw the man and he was wearing a yellow pants and a brown jacket with a hat on his head. And then the witness will just say yes. That's you giving the evidence, describing the man to the court. Now, you can't give evidence, number one, because you as the legal practitioner is not under oath. Remember, I said the court can only consider evidence. So that won't be evidence. The witness just saying yes or no, that's not the evidence. You want to place the evidence on record. So you would ask the witness, describe the man. What was he wearing? That is how you would ask. That is open-ended, where in the witness's words, he will tell the court what he saw. This is now lay witnesses. He will tell the court what he saw. Right. You all know this. If you don't know it, I'll tell it. I know some people don't know it. The rule for not asking leading questions is to start the question with the husband with the 5 wives. I'm not talking about our ex-president. I'm talking about the H is the how, and the 5 wives is why, when, who, what, and where. Husband and the 5 wives. If a question starts with one of those words, then it's always an open-ended question. How did it happen? Where did it happen? When did it happen? Why? Who was there? What did they do? You see, you're not suggesting an answer. The answer will come from the witness. So if you remember that rule, it will be easier for you to ask open-ended questions and non-leading questions. If you ask a leading question, your opponent will also jump up and say, I object. That is a leading question. And then the court will say, stop asking leading questions. You're not the witness here. Right. Another trick that I'm just going to give you these 2 tricks and then I'm going to move on. For examination in chief is to keep your witness on the path that you want to keep him without leading him, without asking him leading questions. That is sometimes difficult. You're going to prepare the witness when you're going to consult with him, but to keep him on track might be difficult because in court, witnesses sometimes change. They see the court, they see the judge, and they just start talking or they can't talk. How do you keep your witness on the straight and narrow and on track with what it is that you want to place before the court is to piggyback. Doing this, what we call piggybacking in practice. Piggybacking is when you take the part of your witness's answer to the question that you've asked and you include that in your next question so that they can't go off track, it can't digress. So the witness answers, you ask, what were you doing? And he said, I was at home. Oh, what were you doing on the day? I was at home. I stood at, I was looking into the road. Where were you when you were looking in the road? Oh, I was by the window in my lounge. So when you were at the window at your lounge, what happened? Oh, I saw this man. He was walking across the street. Oh, who was this man? Did you know him? What was he wearing? Can you see? You will ask part of the previous answer. You will include in the next question, and then it's not leading. And remember, in civil, I must mention this, in civil proceeding, in civil action, so you are allowed to ask leading questions on common cause facts, on facts that are not in dispute, facts that is agreed between the parties. You will say, so we're talking about the 1st of March 2023 when you witnessed an incident. Can you tell the court about it? The fact, the date and that, it was agreed, they admitted that in the plea. It's not an issue, so that is not a leading question. Because otherwise, how are you going to get there to that date if it is? But if it is not, if it's not admitted, if it's denied, then obviously you have to lead evidence on it. But if it is admitted, then you don't have to lead evidence on it. I told you that before. Right. Are there any questions so far? Okay, move on. Cross-examination. Now, you don't cross-examine your own witness. You cross-examine your opponent's witness. Right? After your opponent's witness has given evidence in chief, you now cross-examine him. Cross-examination is attacking the credibility and the reliability of the witness. Testing the veracity of what the witness has said. Checking if he's talking the truth and trying to catch him out. And here you ask leading questions. You are allowed to ask leading questions. You would make a statement and say, so on that day you were not really wearing glasses and you are wearing prescriptive glasses always. And then the witness must just answer yes or no, because that is what you want. You want them to just agree with you on certain contentious issues. When the witness, when you have during cross-examination what you want the witness to have to concede and admit, then you bank that. You don't think, okay, I got you now, and you ask that question again and again so that to show how good you are, because then you give the witness a time to think and to recover and to remedy whatever mistakes they made, because they will quickly catch on, oh, I talked nonsense there, and then you will make it right. You don't. Once you get the answer, you bank it and you move on to the next one. And also, you don't argue with the witness. If you do not agree with what they're answering, don't argue with the witness. During cross-examination, you also would put to the client's version and ask the witness, what does it, so that the witness have it, they know then what your evidence is that is against the evidence that he's just given. So usually, if you finish with the cross-examination towards the end, you will say, look, my witness is coming to say X, Y, and Z. What do you, and you said that, so what do you say about that? But don't argue with the witness. You ask one question at a time. You don't ask a series of questions. Your opponent will jump up or the court will interject and say, which question must the witness answer? Ask one at a time and let the witness answer. Wait for the witness to answer, then ask the next question. But this is all things that you already know, or you will learn it as you go along. Re-examination, the same rules that apply for examination in chief applies to re-examination. You cannot ask leading questions. And re-examination are limited to issues that is raised in cross-examination. If certain damage was done to your witness credibility, which you can save, then re-examine to clear up any misunderstanding, right? And to restore the credibility of your own witness. But if the damage is of such that there's nothing you can do, rather don't re-examine if you're going to do more damage. If your witness was very good and he couldn't be caught out during cross-examination, maybe you also need not clear up anything, then you don't re-examine. But it's your call. As you are there during the trial, you will decide whether it is necessary to clear things up, or are you just going to confuse it more, or should you leave things, or your witness is that good, you don't even have to re-examine. Right, and then we come to the closing argument. This is now after all the witnesses were led, where you would, let me just say something about expert witnesses. If you're going to call expert witnesses, you're going to put on, you're going to put on a record the qualifications and the experience of the witness and why the witness would be regarded as an expert witness. And then you're going to refer the witness to his report, his or her report. And you usually would start with the conclusion. This is what you find. And then you would say, explain to the court what you did, how you came to that conclusion, what is the procedure, and take the witness through his report that is already before the court and put that evidence on record. Okay. And if you have to cross-examine an expert, you obviously would have, in many cases, consulted with your own witness, go through the report of the opponent and get tips as to what, because you cross-examine a neurosurgeon. We're not neurosurgeons, we lawyers. But the other neurosurgeon will tell us, this is what this means, this is what that means, ask this is how you would do that. And so you also learn, but you would have the assistance of your experts in order to cross-examine another expert, if you have experts. Right, so in the closing argument, you will summarize the evidence. You will say the plaintiff led this with had this witnesses, and this is what this witness testified, this is what that. You will argue the substance of your own case. You will identify the weaknesses in your opponent's case. Apply the law, that is now look at the statutes, look at case law, apply it to the facts that is on record and the evidence, and then request the relief sought. That is the closing arguments. Now in high court, usually the judges requires that heads of arguments are, they just rely on the oral evidence. They want it in writing. So when they write their judgments, they have it in writing. So you would do your heads of argument. For those of you who's done heads of argument, it would be simple. You have an introduction, maybe a background, and then you have the issues and the evidence that was led, and then the law. Yeah, and then the conclusion. But there are different ways. People have different ways of doing that. Are there any questions on that crash course in advocacy training?
Sorry, Advocate.
Yes, I'm here.
Yeah, it's Richard again. I just want to touch on where you dealt with the cross-examination, re-examination, and on numerous occasions you would deal with where you want a direct question answer where you say yes or no, and some of the magistrates and some of the defense also jump up, or prosecutors or the defendant's advocate jumps up, and it's unfair. I just want to know, direct questioning with yes and no, is that still permissible in courts?
Cross-examination.
Yeah, with the yes or
During
no.
cross-examination. Yes, it is. That is what you want. You want them to just agree with you. What do you say? The magistrates object if you ask them questions where the answer is just yes or no?
No, not the magistrate or the. Sometimes the attorney would or the advocate would stand up and say, but it's an unfair question for his client to just answer yes or no. They need to elaborate on certain aspects of it.
I don't look. I don't know the context of what you're saying. I know what you are asking me, but I don't know if in the context it maybe there's a reason why they would say that maybe the client did not the witness did not testify on that aspect during examination in chief, and now you're asking a question that he doesn't know of where the answer should be just be yes or no. I don't know if that is the context, but usually yes and no. If they've said something and if you know something, you put it to them and they can say yes or no. It is allowed. I don't know what objection.
Okay. Thanks.
Depending, I mean, I need more information if I need to give you a better answer. Richard, sorry about that. Okay, any more questions on that? Right, at the end of it, the court will hand down a judgment, give a judgment. If it is judgment for the plaintiff, that means the plaintiff is successful. If the court dismissed the plaintiff's case, then that means the plaintiff was unsuccessful and the defendant is. The judgment is for the defendant on the counterclaim. That means the defendant is successful on the counterclaim and the plaintiff is unsuccessful, right? And dismiss the defendant's counterclaim. Right. Remember, the burden of proof never shifts. At the outset, it is determined in the pre-trial conference, you're going to decide who has the burden of proof. And like I said before, whoever has the burden of proof has the duty to begin. Okay, I'm gonna ask you if you have any other questions pertaining to what we did tonight that you didn't ask. This is an opportunity to ask. We have a few minutes left. No questions. Yeah, I'm not going to start with this now because it's going to take me about 20 minutes to finish, and I don't want to do a half-heart. I don't want to get into the half of it. So unless there's no questions, then that would be it for us tonight.
Thanks, Advocate.
Thank you. I'll see you tomorrow. Tomorrow is our final night.
Thank you.
Thank you. Bye-bye, everybody.
Bye.